All matter.
As agreed by learned counsel for both the sides, list the matter on 23rd October. Item number 30.
Lordship.
Item number 13.
12.
12, okay.
Mas. Obliged.
May it please your lordship,
Hmm.
I beg to mention item number 8, lordship.
Hmm.
The matter may be taken up to 4 weeks, lordship. We have taken consent from the other side.
Learned counsel, Mr.
M. Ahmed.
N.
M.
M. Ahmed, on behalf of learned senior counsel, Mr.
M. S. R.
Ishar
Chaudhary.
Chaudhary, with the consent of the other side, is paid for adjournment. List the matter. When do you want?
After 4 weeks, lordship.
Madam, I beg to mention
Yes, yes.
item number 17. Today I am having some eye problem. This
Mhm.
matter
Eye
was
problem?
17.
Okay.
Item
Have you
17.
taken consent from the other
I
side?
appear for the response.
Okay, okay.
This may be taken tomorrow.
Okay. Tomorrow?
Obliged.
Tomorrow, fine. Too many matters tomorrow.
No, Lordship, my learned friend will not remain here. He is living for USA from.
I'll not be there in the
From
first
first
2
of-
weeks. If your lordship is not having it tomorrow, may I pray that the date be fixed after 16th, madam?
No, matter is urgent matter. It may be taken tomorrow.
Detail.
For 15 days, my learned friend will be out of state.
Okay.
Obliged.
Obliged.
Learned counsel, Mr. S.P. Roy.
Yes.
SP Roy.
S.P. Roy has prayed for adjournment as he's not, as he's suffering from eye problem.
Yes, Lord.
Okay. I list the matter on.
Obliged.
Obliged.
May I please your lordship?
Hmm.
Lordship, with the consent of the other party, opposite party,
Hmm.
I would like to mention item number 11.
Cannot hear you. See, just check the speaker. If it's okay.
Lordship, I beg to
Is it
mention,
on? Speaker is on. Okay. Please loudly.
Lordship, I beg to mention item number 11. The
Hmm.
matter may be adjourned for a week. We have also get the consent of the opposite party.
Okay, learned counsel, Mr. Your name? What is your name?
A. Muhammad. I'm on behalf of M.K. Sharma, advocate for the petitioner.
M. Mohammed, on behalf of learned counsel, Mr. M.K. Sharma, with the consent of the other side, has prayed for adjournment. When do you want?
For a week.
List the matter after 1 week.
Obliged.
Lordship, with consent of the other side, I beg to mention item number 16.
Hmm.
I am appearing on behalf of the respondent number 1 and 2.
Learned counsel, Ms.
Miss V. Rai on behalf of Miss S. Biswas.
V.
Rai
Rai. On behalf of learned counsel, Mr.
S. Biswas.
S. Biswas, with the consent of the other side, has prayed for adjournment. List the matter on
After Puja vacation.
after Puja vacation.
Obliged.
Right, please, your lordship. I beg to mention for listing of MSc appeal, lordship. Right.
May I please your lordship? The conducting council is on late, so can we take the matter after some time?
My lord, here, my lord, in this matter, my lord, one reply has to be filed from the side of the petitioner, my lord. My lord, regarding an affidavit, my learned colleague, my lord, PS Lohkar was appeared, my lord. Here, my lord, he has submitted what I understand from the, my lord, the note and that, my lord. On that, my lord, that reply, affidavit in reply has to be filed, and that was not on record, my lord.
Your lordship, I'm not aware about the case, so kindly give us some time.
Okay, after some time.
Thank you.
May please, your lordship. My lord, in this matter, my lord, my prayer was twofold, my lord. Number one, that the petitioner, my lord, he, for a considerable period of time, having certain health issues, mainly kidney problem, my lord. And second is with regard to the factual aspect of this case, because earlier this bail petition was once rejected and Honorable Court never divulged into the factual aspect of this case, my lord. So the second, my prayer, my lord, is that with regard to the factual aspect, that till date, my lord, there are altogether 32 numbers of witnesses, 29 numbers of witnesses have already been examined. And my lord, from the perusal of all the statement, ocular evidence of all the witnesses, my lord, clearly, my lord, no case is made out against the present petitioner, my lord. Only 3 accused persons, they have been implicated.
How many days you are behind bars?
My lord, he is behind bars, my lord, since 6/1/2025, my lord. Earlier he was 6/1/2025, last arrested. Prior to that also he was in jail, my lord.
No, in this case,
Just to go by 181 in a set.
in this case,
6/1/2025, my lord. Earlier, my lord, the factual aspect,
no, earlier is not required, only in
My
this
lord.
case.
My lord,
6/1/2025.
What is the section?
302, my lord.
Here, my lord.
It will be 103,
my lord, my lord.
or it is an old.
No, earlier, my lord.
Earlier, my lord.
Earlier,
Prior to 2023, my lord.
my lord. Prior to
So
that, my lord,
IPC, my lord.
302, my lord.
You are suffering from kidney problem.
Kidney problem and high blood sugar, and he collapsed twice in the jail premises, my lord. He was admitted in Borpeta Civil Hospital. He was there, then discharged, my lord. Now he is having affected in his eyes also, my lord. So good variation.
Okay, what do you have?
My lord, I am not able to go through the entire, my lord, record, my lord. This is too voluminous. My lord, if my lord allows some time, my lord, today itself I can go
Okay,
through, my lord.
okay. After some
Otherwise, my
time
lord,
then.
there is one, my lord, medical report that I have gone through, my lord. That was flag
From
mark
the
also.
jail?
Yes, my lord. That is, my lord, received, my lord. On earlier occasion, my lord was pleased to direct, my lord. From the jail authority, one medical report was sent, my lord. That is available, my lord. The detailed report is there, my lord. That is flag mark, my lord. One horizontal flag I have also flagged there.
Okay, after some time.
My,
We'll hear him after some time.
Pray, my lord, second half, my lord.
Second half, okay.
at 2 then, my lord.
At 2, yes,
I know.
at 2.
Deeply obliged.
My,
At 2 di diba, ha?
Deeply obliged.
It's a reputable age.
My lord, in the
Service report on respondent number 2 is awaited.
awaited, and my lord, the trial court reports are also not received.
Okay. Service report on respondent number 2 is awaited. Trial court records as called for is not received. Issue reminder to forward the trial court scan copies of the trial court records along with the scan copies of the entire CD positively on date of the date. So 8 September.
Obliged.
In this case, my lord, I was granted interim bail, my lord. I appeared, my lord. And the petitioner before your lordship is a minor, my lord.
my lord, here, my lord, we have received the CD, my lord, both my lord 4 and 5, my lord. The same PS, my lord. My lord, allow some time, my lord. I need some time, my lord, to go through it.
One having it, my lord.
He's not behind bars, maybe on Monday?
My lord.
On Monday?
My lord.
Please give me that judgment on minor,
I think it's there, my lord.
anticipated bail.
My lord, because your lordship had granted the interim bail, my
Oh.
lord. File more silent. I'll go through it, my
Learned additional PP, Mr. K. Bosher has prayed for time to go through the CD list the matter on Monday.
Monday, my lord.
On Monday. Interim
Yes.
order shall continue till then and CD to be retained till then.
My lord, deeply obliged.
I'm obliged.
This is the same affair case, my lord.
My lord, 4 and 5, same, my lord.
Okay, Monday then.
My.
You are on
Interim
interim
asset-
bail. Are you on interim bail?
No
No,
interim.
no, till Monday then.
Well,
এইটো একে order লিখি দিবা খালি interim order নিলিখিবা হা interim order নাই ইয়াত same case.
Deeply.
Right, please, lordship.
Is awaited.
My lord, we have taken steps upon respondent number 2. And lordship.
Respondent number 2 is here.
Oh.
You have for respondent number 2?
Yes, lordship, I have for respondent number 2.
We have the CD?
My lord, CD not received, my lord, in this matter, my lord.
My lord, lordship may kindly see, this is the FIR is the outcome of love affair of 2 minors, lordship.
It's
My
okay,
lord,
it's okay.
Other
No
family,
problem. We'll-
other were not on protection, lordship. Other family members may be protected. We are brothers, lordship.
You have any objection?
No, your lordship.
Other family members, petition number 1, 2, and 3. And 4 is the
They are brothers.
brothers. 1, 2, and 3 are the brothers, lordship. 4 also may be considered because he is a minor, lordship. He is a minor.
Where is the FI?
Lordship may kindly see FIR page 11.
Please read.
Respectfully beg to state that on 3/12, it is a typographical error or say 3/1/2025 at about 8 p.m. My daughter, namely so and so, went to school.
Mr.
Kianuddin.
Post of the K.N. Chaudhary.
Kianuddin.
And Hussain, learned counsel for the respondent number 2, and Mr. K. Bushra, learned additional PP Assam. The allegation against the petitioners is that they have induced the minor victim X to elope to get married to whom?
Accused number 1.
To accused number 1 named in the FIR.
Yes.
The learned counsel for the petitioner has submitted that the annexure
2
of the petition is the affidavit filed by the informant. He is the
Informant, Lordship.
filed by the informant stating that they have settled their issue amicably and there was no threat and coercion or inducement from the petitioners to induce the victim to elope in order to get married to the petitioner to the accused number 1 named in the FIR. CD is not received. The learned counsel for the respondent number 2 has no objection if the petitioners are enlarged on bail, anticipatory bail. Call for the CD, list the matter of.
My objection may be recorded.
Yes.
Because my POCSO matter.
Learned additional PP has raised serious objections stating that interim bail may not be granted as the petitioners are booked under a POSCO case. I have considered the submission that an affidavit has been filed relating to the incident, that there was no coercion on the coercion to induce the victim to elope to get married to the petitioner number 1. Full stop. The petitioners are willing to cooperate with the remaining part of the investigation. In the interim, the petitioners shall be enlarged on bail of rupees 50,000 each to the satisfaction of the learned arresting or to the satisfaction of the arresting authority, under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Number 2, the petitioner shall refrain from such activities with which they are alleged. Number 3, the petitioner shall not exercise threats to the witnesses or try to tamper with the evidence. On breach of any of the bail conditions, bail order shall automatically stand cancelled. Send back the shall automatically list the matter of 19 September.
All the petitioners, Lordship.
All of
Deeply obliged, Lordship.
Please, Lordship, I am appearing on behalf of Mr. P. Chaudhary, Lordship. He has some personal difficulties and he is physically ill. So he has to ask you over telephone, my lord, to checking time. And he has already informed Mr. Lanet Senior Counsel, Mr. P.K. Kolika. And he has no objection.
My lord, I'm on behalf of PK Kolita, my lord. Kindly fix the case next week, my lord.
next week.
Next is, my lord, can it be fixed after 13th of September, Lord?
Can be fixed after 30th of September.
13th of September.
Learned counsel, Mr.
M. Das, on behalf of Mr. P. Chaudhary.
M. Das.
M.
On
Das.
behalf of learned counsel, Mr. P. Chaudhary has prayed for adjournment. Learned counsel, Mr.
PK Kolita.
Your name?
Islam.
A. Islam is present on behalf of learned counsel, Mr. P.K. Kolita. List the matter of 18 September.
Obliged, Lord.
May please, your lordship. Lordship, I pray for matter may adjourn for today, lordship. Only
You have
for
taken
today,
consent to the other side.
no, lordship.
You'll have to take. What is your ground?
Lordship, personal difficulty, lordship. Leave application is also there, lordship.
Okay. Where is the leave? What is your name?
A Begum on behalf of S. Banik.
As Banik, no?
Yes, lordship.
ইয়াতটো নাই নামটো লিভ নোট নাই
Reflect on cause list of it.
কজ লিষ্টত আছে নেকি
S Banik. Supply list আছে. Supply list.
okay learned counsel Miss
F Begum.
F. Begum has submitted that she is present on behalf of learned counsel for the appellants Mr. S. Banik, who has circulated a leave application as he is indisposed. Huh?
Yes.
List the matter on when do you want?
Any date person.
Oh. 18 September?
Public.
Item number 8.
Please, Your Lordship, kindly pass over the matter for time being. My senior is on another court.
Petitioner is also not present. So, কি কেলে ইমান দিন পৰি আছে 2015 ৰ পৰা actually এইবোৰ পুৰণা মেটাৰবোৰ নতুনকে দিছে নেকি তেনেকুৱা যেন লাগিছে মোৰ 2024 আছিলে the side has paid for listing 11টাও বুজা নাই হ'ব after some time yes after some time
Bless.
10 আছিলে ন
May I please, Your Honor? I'm appearing on behalf of learned senior counsel GP Bhumi. Lordship, kindly adjourn the matter for the day. My senior is ill, Lordship.
My lord, that may be fixed, my lord. And it should be taken on the next date, my lord.
Yes,
25th of.
very
Sep-
old matter no
Yes, my lord. That's why no further
Under
adjournment.
RSAC
Yes. 25th, my lord, and for final hearing.
Miss
R. Kaur, Lordship.
learned counsel Miss
R. Kaur.
Gaur
Kaur, yes.
is present on behalf of learned counsel Mr. GP Bhumi, learned
No,
counsel Mr.
25th is the third Thursday, na?
Your government advocate,
Acha.
government advocate, your government advocate,
No, I am for respondent, our main
sole
respondent.
respondent.
Sole respondent.
Learned counsel Mr.
K.U. Ahmed.
KV Ahmed is present for the respondent number
1
1.
in both the cases.
দুইটা একেলগে লিখি দিবা respondent number 1 list the matter positively for hearing on 16 September.
My lord,
As this is
16 September, another two matter in this court already fixed, my lord.
Oh,
That
no,
is not
okay.
possible, my lord.
after puja.
Puja, my lord, just a second. Puja. My lord, 16
September.
September.
16 October. Yes, yes. Positively for hearing as this is an old pending case on 16 September, October.
Obliged.
Obliged.
May I please, Your Lordship? Your Lordship, now kindly pass over the matter for the time being. Mr. D. Chakravarti.
Time being?
Yes.
All right. 15 Niki?
50.
Just a moment. If this matter will be over, then I'll sit at 2. Yeah, at 2.
Item 1.
Mati. Yeah, so.
তোমাৰ পাৰ্টটো হ'ল দে ৰিপ্লাইটো দিছা
না দিয়া নাই।
দে Let please, Your Lordship. Lordship, this bail application in connection with special case number 511/2024 arising out of Columbus Police Station case number so and so under section 22C and the best associated matter, Lordship.
In this case, Lordship, as on today, I am behind about 494 days, Lordship.
494 days.
Lordship.
Last time also you said you are behind the bar for 494 days. I have
Sorry,
noted
Lordship.
down, huh?
Sorry, Lordship, 501 days.
Huh?
501 days.
501 days.
16 months, 14 days. Lordship, recovery was 720 numbers of Prion Express Plus capsules and 119 Roscoff cough syrup, which is codeine cough syrup. And no actual weight is mentioned in the inventory, Lordship. And inventory is there. In case number 25, Lordship. In case number 25, Lordship.
Okay. Yes. Yes, I
Only
have also
number
seen.
of.
Weight
na-
is not mentioned. I have also seen.
Yes, Lordship.
Hmm.
Lordship, and regarding grounds of arrest, Lordship, nothing is the Lordship, page number 39 and 40, Lordship.
Now you cannot plead on grounds of arrest. There is a new judgment.
Yes, Lordship, I have gone through Lordship, sir. Lordship, in
Page
the
number what?
page number 39 and 40.
In
Lordship.
serious offense, you cannot plead grounds of arrest. Maybe in offenses under 7 years, you can plead, but not in serious offense. Page number what?
Page number 39 and 40, notice. This is State of Karnataka versus
How many
Darshan.
witnesses have been examined?
7 witnesses as per LCR law.
7 witnesses.
7 witnesses.
So why don't you take the pains to finish up the case? This is a good case because their weight is not mentioned. Not good case for bail, but good case for acquittal. Why don't you take the pains instead of coming for bail again and again? Why don't you finish up the case there?
Lordship, in this case, Lordship, all the witness has been done, but all the public witness has been done. These are all favor of me, Lordship.
That is what I'm saying.
Yes.
You have a good case for acquittal. So you go to the lower court and you press for quick disposal.
Lower court is not granting Lordship.
How many witnesses are yet to be examined?
Most only 3 witness, Lordship.
See, if you insist, if you always make a prayer, then the court will act fast. You give a petition that I'm suffering from, I'm suffering immensely as this is a procrastinated case. So it has to be disposed of or evidence has to be closed. If you give a petition in that manner, that case will be expedited. You do not have a good case for bail, but you have a very good case of acquittal. Why don't you proceed there?
Lordship, actually given petition last time, but not given the bail.
You have given petition.
Lordship. Not granting the bail, Lordship.
Okay, I'll see. I'll see. What do you have to see?
My lord, record I didn't go through, but my lord, regarding the law point, my lord, as because the ground of arrest, so
State
my
of
lord has already aware, my learned colleague also submitted, my lord. That those position now, my lord, there is the state of Karnataka versus Darshan's case, my lord. That is my lord, 21 point, that is 4 para, my lord. My lord may have that, my lord, there is a
Yes, yes,
judgment
yes.
available with.
Just a moment. State of Karnataka versus
My lord, state of Karnataka versus, my lord, Sri Darshan, etc.
what is the citation ruling? Or what is the citation?
Citation is, my lord, it is 2025 INSC 979, and also I am providing the, my lord, SCC also, my lord. That is SCC is, my lord.
We do not have INSC.
My lord, that is available to all, my lord. INSC is, my lord, SCR, my lord, Supreme Court report, my lord. It is available by the by the Honorable
In the
Supreme Court
website.
website, my lord. That is available to all, my lord. It's a free, my lord.
Free, no?
No, free, my lord.
Okay.
Now it is available from PV Council to till today's judgment, everything.
INSC.
INSC, my lord.
Okay.
Well, that is SCR. Actually, it is available in the Supreme Court
Website.
report, SCR. my-
No, there they do not go. There they do not serve. From my office,
My
there
lord.
they do not serve. They take the SCC only.
Yes, man.
So
My
you
lord,
give me the
SCC also,
SCC.
we have SCC also, my lord. Both we have, my lord.
The Supreme Court website, nobody goes there. It's very difficult because so many judgments you have to select.
My lord, 2025, my lord,
Hmm.
SCC online,
Hmm.
SC 1702, my lord.
Paragraph?
Para, my lord, relevant para is 20 point, from 20.1, my lord.
Okay.
It is started, my lord. May I read only, my lord, one para, my lord?
No, not required.
Yes, ma'am.
That day he has read.
And regarding, my lord, inordinate delay also, my lord. In another.
I know.
Yes, my lord, that, my lord, Kallam Sarkar judgment is cited, my lord. Court, and regarding, my lord, appreciation of the evidence in those, my lord.
Everything is cited, yes.
Yes, that is also, my lord, cited, my lord. So it should not be a mini trial, my lord.
So you want time to go through the LCR?
If, my lord, on this point, my lord, this is the issue, my lord, then this is my submission, my lord, because already, my lord,
This is
hard.
the ground.
Then, my lord, this is my submission, my lord. And that citation, if, my lord, say, my lord, I will give a print copy of that, my lord.
He is also taken pressed one ground that weight is not mentioned.
Yes, my lord. Yes, my lord. But otherwise, my lord, there is a written kind of, my lord, that is affidavit was to be filed, but my learned friend stated that no, he will verbally, my lord, submit it on the Darshan's matter.
So last time also, actually, I'd say I'd taken time for verbally submission actually, Lordship. Lordship, in this case, Lordship, my learned friend, whatever said, point number 21.1.
There are many points.
Lordship, that one, this is submission for by the council, Lordship.
No, man.
This is the learned council for the respondent submission. So
No.
this is the submission point.
It is not the observation of the Supreme Court. Only submission by the council.
No, my lord, it is the observation, my lord. My learned friend will submit, my lord. Thereafter, I will submit.
That's all, Lordship. This case purely, Lordship, for the cancellation of bail, Lordship. This was for cancellation of bail. In this case, Lordship, for the P02 murder case, and the bail was cancelled for the purpose of medical.
I'm telling you, see, I'm just giving you an advice. If this is a cancellation of bail and if bail has been cancelled, then please don't harp on this judgment. Because cancellation of bail even needs more
Yes, Lordship.
intricacies. So this bail was cancelled.
Yes, my lord, that is
So
cancelled.
please don't harp on this judgment.
Lordship, that's why
You
I'm
take a
saying,
better.
it has been cancelled, that's what I'm saying. Lordship, this was cancelled for.
Yeah, that is what I'm saying. Granting bail you need less grounds. For cancellation of bail, you will need more intricacies, more grounds.
No. Lordship, in this case, Lordship, what then?
No point. If you're stressing on this point, cancellation of bail, there's no point. There is a decision that if you cancel the bail, you will need more better grounds to cancel the bail.
Yes, Lordship.
To grant bail, you don't need so much of.
The bail was granted on the ground of medical grounds, Lordship. Urgency is there, urgency was there, but.
No, see, why you are harping on that judgment? Don't harp on that judgment. I'll take your submission as it is and then I'll decide the case. That judgment you cannot assail. You cannot. If you have another judgment, you can assail, but that you cannot assail. Bail has been cancelled. I'll decide on whatever you have submitted. I'll decide it.
Lordship, grounds of arrest may be considered as Bihan Kumar judgment is there.
Okay. I'll see. Vihan Kumar and this judgment, I will see. I will compare and then if possible, I'll grant bail and if not possible, no.
Lordship.
But I give you a good advice. You insist on completion of the trial. You have a good case.
Yes, Lordship.
I think you also have to go through the LCR.
No, my lord, because on the law point, otherwise, my lord, that is what my learned friend has submitted, my lord. That is the, my lord, that is a contention of that time, my lord, that.
Advocate, yes.
That is not, my lord,
Check whether it is
because, my lord, in
submission of the.
yes, my lord, because, my lord, para 18, my lord, that is, my lord, the Honorable Supreme Court, my lord, stated, let us now examine the jurisprudence on when bail may be annulled or cancelled. Two distinct categories have emerged in this regard. So thereafter, my lord, a annulment from 18.1. This is the, my lord, that is the, my lord, the Supreme Court's, my lord,
Observation.
observations, my
I'll
lord,
check, I'll check.
analysis.
এইটো হেৰি কৰি দিছো, এইটো একেলগে দি থৈ দিয়া। এইটোতো কাটি দিলো ন, কাটি দিলো, এইটো দি থৈ দিয়া, ইয়াৰ ওপৰত দি থৈ দিয়া, ডেটো টাইম ন, মোৰ এইবোৰ জাজমেন্ট কেইটা পৰি আছে, আকৌ হিয়াৰিং আছে, এইটো কাটি থোৱা আছে।
My lord, I will provide a hard copy, my lord, along with the relevant parameter.
Okay.
Of
So anybody is waiting for time being, then I'll sit at 2. Don't worry. I'll sit at 2. Don't worry.
my lord.
I have good 3-4 matters for time being, but your seniors are in another court, so I'll sit at 2.
মানে আগতে আছে আগতে আছে 200 Now, my lord, it is 235 days, my lord, behind the bars. Calculated.
Yes, my lord, I have gone through the, my lord, entire, my lord, record, my lord, also, my lord, the petitions, my lord. Here, my lord, these are, my lord, earlier rejected on 24/4/2025, my lord. And thereafter, my lord, my lord, they approached before the Honorable Supreme Court, my lord, by filing an SLP, and that was also, my lord, dismissed, my lord. Now, before your lordship. Now, my lord, here, my lord, one, my lord, that is a medical, my lord, that is the report was called for. Now, it is on 2 grounds, my lord. This bail petition is after, my lord, that is the SLP dismissed, my lord. On 2 grounds, new grounds, my lord, they filed it. One is a purely medical ground. Another is the, my lord, merit of the case, my lord. Now, my lord, regarding the merit of the case, my lord, that is a, my lord, that is a state of Karnataka versus Darshan, my lord. Already, my lord, in earlier occasion, my lord, I have
Yes.
submitted, my lord. That is, my lord, categorically stated, my lord, regarding, my lord, that is in regarding, that is the appreciations of the evidence, my lord, and the merit in case of a bail petition, my lord, it is categorically stated that it is a settled principle that at the bail state courts are precluded from undertaking a detailed examination of evidence and rendering the findings the touch of the merits, my lord. So, my lord, in this regard, again, if I can submit, my lord, the same, my lord, regarding that point of view. Now, my lord, regarding that is the medical, my lord. The one report is there, my lord. That is the flag mark with the, my lord, the main petition, my lord. Later, my lord, one, my lord, flag, horizontal flag there, my lord, for your lordship convenience, my lord, I like there, my lord. Last part, my lordship, he was given treatment, my lord, proper treatment, my lord. He is under medications, my lord. There was hypertension, my lord, kidney disease, and my lord, regarding his, there is diabetes, my lord. 3 are there, my lord. But regularly check up, and my lord, that is the medication is given, and my lord, already as per the submission of my learned colleague, that there is out of, my lord, that is 32 numbers of PWs, my lord, 9 have already been examined, my lord.
Yes.
My lord. So, my lord, so far as the health aspect is concerned, my lord, that report will say, my lord, because I cannot see the report because it has been,
You can see the report.
my lord. Otherwise.
My report is there.
You
His
can see the report.
documents, that so far I have gathered from him, my lord, I have placed before his honorable court. Sum and substance, my lord, it is a kidney disease, my lord. And within a very short span of time, his creatinine, my lord, it increased to such an extent which is a clear indicative that, my lord, he is not getting the treatment which is otherwise needed for a kidney patient, my lord. And the treatment is also, my lord, it is not such, my lord, which is under normal circumstances person can get. Entire, my lord, his food habits has to be changed, entire lifestyle has to be changed when a person is affected with kidney disease, my lord. That to my limited knowledge, I know, my lord. His diet and everything, my lord, has to be in a very controlled manner. And if needed, my lord, he has to go for dialysis, my lord, as and when necessary, my lord. That is the requirement of a kidney, my lord.
No, dialysis is not required.
My lord.
According to the doctor, dialysis is not required.
No. In these particular cases, may not be there, my lord. Otherwise, in normal circumstances, I am submitting, my lord. Normal circumstances. Here, my lord, his kidney.
Why was his, haven't you taken this plea in the Supreme Court? Why was his bail
Yes,
rejected in
my
the
lord,
Supreme Court?
that time his health was not such, my lord, that is.
No, that's not very long ago. It's only recently, very
Recently,
recently.
my lord, his health condition deteriorated, my lord. Very recently, my lord. 6 July, my lord, 2025. 24 July 2025, his creatinine reached 2.330, my lord. Page 116, I have an my lord. And his leave, altogether, my lord, his leave was not entertained. That is what my lord tested us, my lord. And that is why, because on the earlier occasion, my lord, I already submitted at page 110, the honorable court, my lord, did not brought to fore, my lord, the merit of the case, my lord. It was not discussed. Now, my lord, as my learned friend is submitting, that, my lord, the merit of the case need not to be taken into consideration, my lord. There are stages when, my lord, bail petitions can be filed. First, my lord, it can be filed before submission of charge sheet, my lord. Therein, the only condition that the honorable court will see that whether his custodial detention would be necessary. But once a charge sheet is filed, my lord, then the honorable court will see the factual aspect and the merit of the case as well. But in this particular case,
You
my
see,
lord.
why I have passed this order, a very long order.
My lord.
Almost like a judgment.
My lord.
This bail order is almost like a
Allegation is
judgment.
very serious, my lord. Contacted my lord, other my lord killers by giving my lord 13 lakhs of amount, my lord. All things are there, my lord. From the serial analysis to all this, my lord.
Not discuss the merits.
My lord.
And my lord,
Now,
it is the motorcycle, my
you.
lord, used, my lord,
My lord.
in this case.
This is to your detriment. Why I have not discussed the merits?
My lord. But now, my
To
lord.
benefit you, I have not discussed the merits. If you want, then I'll discuss the merits.
My lord, now is the situation I have seen 29 numbers of witnesses. As my learned friend is submitting, paying some amount, criminal conspiracy, anything, nothing on record. If my lordship goes into the merit of the case, my lord, the statement of the witnesses, nothing on record which remotely suggests that, my lord, he has done any, my lord, such act, my lord, of paying someone.
I'll check.
Prior meeting
I'll
of
check.
mine.
Because this
My lord.
record is voluminous, I cannot pass an order.
Only, my lord, there is, because in allegation is against 3%. So one was holding, another one committed the injury, and one was, my lord, staying in a motorcycle, and 3 of them fled away in the motorcycle. That was the sum and substance of the allegation. Now, my lord, police seized 2 numbers of bikes, my lord. One bike from petitioner, the other bike from another person, and there is absolutely nothing on record which remotely indicates that he is anywhere involved with this present case. And then why an innocent person is like behind the bars, my lord? That question comes, my lord. There has to be some material against a person to be behind the bars.
I'll check. I'll check.
My lord. And
Because you see, I'll need some time.
my lord.
Just take a look at this record.
That is my
I'll need some-
immediate, my lord, because if anything is there on record, that my lordship will find out, my lord, on perusing the record,
Yes,
my lord,
yes.
on the statement of the witnesses, 29 numbers of witnesses.
I'll also consider his ailment.
My friend is submitting on the basis of the charge sheet, but that is long gone. Now witnesses have come and they have deposed their statements. Ocular evidences are before this honorable court now. Now the honorable court can appreciate the ocular evidence and see if anything is there, my lord. That
Yes,
is
is
my,
at the back end of trial, you see.
my lord,
Only 3 witnesses are left
Three
to be
witnesses
examined to
left, my
close the
lord.
procedure and evidence.
my lordship.
Even my
That
lord,
is
there
because,
is,
my lord, why I am,
I'll consider his ailment also.
my lordship.
I'll
Deeply
consider
Deeply obliged,
certain points together, but at the same time, I'll consider the gravity of the offense also.
my lordship.
And whether bail can be considered at this
My-
stage, whether he will be hampering the evidence, everything I'll consider.
My lord, deeply obliged.
my lord, regarding that is the use of that motorcycle, my lord. I have flag mark, my lord, one, my lord, that is maybe, my lord, that is deposition of the witnesses, my lord. That is where, my lord, that is the belongs to this person, one, the motorcycle, which is used, my lord. That is also there, my lord. I have flag mark, my lord, those parts, my lord.
I have seen, my lord, that part. That is why I am submitting.
Delivery order
Deeply
কাৰণে ৰাখি থৈ দিবা। এইটো লিখি দিবা, হা? Hard letter counsel Mr. Yon.
MK Das.
Huh?
MK Das.
For the petitioner. ঠিক আছে। তো ইমানখিনি লিখি থৈ দিয়া, নামটো, হা? ডেটটো পাহৰি যাম যে, ডেটটো লিখি দিয়া। ঠিক আছে বনাম। এইটো ইয়াত পিন কৰি দিবা দেই। দুখন কাগজ আছে। ইয়াত স্লিপটো নহয়, তাত ডেট।
I'm highly obliged.
Mm.
Deeply obliged.
Item number 10 for hearing.
May I please, your lordship, my lord, the appellant herein was the defendant number 1 in the suit. And the respondent number 1 was the plaintiff.
Mm.
The plaintiff not appeared, my lord.
Mm.
My friend has appeared for pro forma respondent number 7, who was in plaint was respondent number defendant number 8.
Okay. You are the
Defendant number 1, defend in the suit, ma'am. And as per office note 15/12/15, the service on plaintiff
Mm.
was complete, my lord,
Mm.
but not appeared before this honorable court.
15/12.
15/12/15. Service was complete, my lord, but not appeared.
15/12/15.
Yes, ma'am.
Plaintiff is respondent number.
Plaintiff, respondent number 1. So, my lord, as per order dated 28/9/15, this honorable court framed a substantial question of law in this matter, my lord. This substantial question of law was formulated, my lord.
15/12.
28/9/15.
There's nothing in the record about service of notice to plaintiff. No, only office note, but nobody has recorded about service of notice to plaintiff. Respondent number 1.
Yes, as per my note, my lord, I have
Nobody is
noted
appearing for respondent number 1.
none appeared, my lord. Till date, none appeared, my lord. It is a case of 2015, my lord.
Good substantiation.
See, there may be an office note, but court has to pass an order. There may be an office note, but court has to pass an order.
Yes, madam. She is correct.
I'll just check, huh? I'll just check.
Yes. Yes.
Substantial between two claims.
You are talking about office note dated?
My lord, it was 15/12/2015.
Any Lauzima court's order?
He ordered to no
I have not verified, my lord.
There's a Lauzima court order also.
ground regular substantial vision point. What a different question. Order.
AD cards returns from respondent number 1 and 8 answer notice returned from the following respondents. No service, no, there 15/12/15.
15/12/15.
There is no service of notice of respondent number 1.
Office note, my lord, I had noted.
Office
that-
note 15/12/15.
Yes, my lord.
AD card returns from respondent number 1,
1, yes.
2D, 3, 4, 6, and 8. But nothing, whether it has been served or not, it has not been mentioned.
What order they Reporter said, court should pass an order.
What is the name of respondent number 1?
One is Abdul Khalik. Abdul Khalik, he was the plaintiff.
Yes, he has received. Mohammed Abdul Khalik.
Yes, he was the plaintiff. my-
30/10/2015.
Yes, my lord.
He has received.
Yes, he was the plaintiff, my lord. And others, my lord, are the
Abdul-
defendants.
Abdul Khalik, he has received.
Yes, my lord. He was the plaintiff and others are the defendants. They are the respondents.
Not take the status of service above the
So, my lord, the
We-
substantial question of
Can
law.
we proceed, I think? He has received the, but he has not appeared, but
Yes.
nothing is, no order has been passed.
Yes, my lord. So formal order of this honorable court is required to
Formal order
Recording.
can be passed today itself, my lord, as per office note. That service is complete, my lord.
And I have
Madam,
served
we
the
have-
record. I do not find framing this issue, my lord, substantial
Substantial of
question
law.
of law. I do not.
My lord.
And notice whatever served to me, the order contains,
No,
that
it has
does
been
not,
framed.
my lord.
29.
28/9/2015 has been framed. Before admitting the appeal, it has been framed and thereafter notices have been issued.
29.
After framing the substantial question of law, notices have been issued.
Yes.
It has been framed.
29/5/2000.
So, my lord, the
29/5/2015.
29/5.
15.
28/9.
28/9.
28/9/15.
You have for respondent number?
I am 47.
7.
Defendant number 8, but in the appeal, respondent number 7.
So, my lord, the case of the plaintiff was
Others are not appearing.
others not appeared.
Notices have been served to most of them.
Yes, my lord. 15/12.
Only respondent number 7
Only appeared, my lord.
has appeared
Yeah, yeah.
and you are the defendant.
Defendant, my defendant number 1, my lord.
Only one defendant.
Other respondents are the defendant in the suit, man. Other respondents were the defendant in the suit, man. So I am one of the defendants. I am the
You are the sole appellant here?
sole appellant. Sole.
I'll just continue with the hearing.
Yeah.
Let me just check all the notices, whether all the notices have been served.
Yes, your lordship.
It was Saidi Bani. Yeah, এইটো চাবা হা এইটোতো আব্দুল কাদিৰ হয় এইটো চাৰ্ভ হৈছে হা এইটো আব্দুল খালিক এইটো চাৰ্ভ হৈছে আব্দুলে চাৰ্ভ হৈছে মোক খালি তেওঁলোকলৈ চাবা হা এইটো চাৰ্ভ হৈছে তাৰপিছতে on that খালৈ বিবি এতিয়া legal heirs হলে serve হৈছে নে নাই? 2A, B, C, D তাৰপিছত এওঁলোকলৈ serve হৈছে নে নাই? এইখিনি চাই দিলে হৈ যাব। 6 লৈকে চালে হৈ যাব। 9 struck off হৈছে। Sub register কৰিম কাৰণ 8 এইখিনি supplementary ফাইলটো তাতো থাকিব সার্ভিস নোটিস বেলেগ এটা মেটাৰ just a moment just
27/9/16 Lozima court order is there. 27/9/16, kindly load. 27/9/16 Lozima court's order.
please read the order.
My order is not here, but it deemed served. Respond number 5. 5 deemed served. And others 15, 12, 15 is reported there.
R1 served.
R1.
R5 served.
R1 served, my lord. And 2
Lozima court order.
Rozima R5. R5 deemed served.
Okay.
27/9/16 deemed served 5. And others, my lord, complete as per order 15, 12, 15. Regarding others 15, 12, 15, my lord. 9 struck up and 7 is my friend appeared. Okay.
2C is deemed to be served.
5, my lord.
5 and 2C
5 and 2C. Yes,
deemed to be served on
Yes, sir.
respond number 2C and 5.
Yes, ma'am. Yes, ma'am.
So
And 2B, my lord, 17/8/16. AD returned. 2B, my lord.
AD card, no?
AD returned, my lord, 17/8/16. Official.
What is the name?
My lord, 2B, Abdul Malik. Abdul Malik is 2B, 17/8/16. my lord.
কিন্তু আছে নামে সামে আছে yes sound yes 2B no
Yes, ma'am. 2B.
we have the RC also
Yes, ma'am.
2B yes served again side le বেশি টাইম না লাগিব just a moment
My lord, 2A 4416. 2A 4416 office note, my lord. AD returned.
we'll check
Oblige.
নাম কিটা side le
Oblige.
we'll check we'll get back to you after 5 minutes
Oblige.
till then we will take up another matter
Wait, please, your lord.
yes
My lord, the second appeal is directed against concurrent finding against me. The second appeal is directed against concurrent findings by both
Concurrent
the,
findings, okay.
yes, by both the courts below against me in the sense.
you got a plaintiff or a
No.
defendant
I am the defendant number 6 in the suit. And I was the appellant in the title appeal. Now, the suit was decreed in favor of the plaintiff. The suit was called Declaration of Right Title Interest and Recovery of Khas Possession. Allegation of dispossession, and there was the prayer for recovery of Khas Possession. The suit was decreed in favor of the plaintiff, who happens to be the respondent number 1 in the instant appeal. And thereafter, I preferred title appeal. That title appeal has been dismissed, upholding the judgment and decree passed by the learned trial court. Now, against these two concurrent findings, I am here before this honorable court in regular second appeal. And by order dated 7/11/2019, this appeal was, second appeal was admitted for hearing on only one substantial question of law.
My humble prayer, my lord, your lordship kindly peruses this order dated 7/11/2019 for a while. My lord, this, my lord, brief is a second-hand brief for me. This was actually earlier dealt by another head of council.
Okay.
So, my lord, I'll try to assist my lord to the best of my ability. Your lordship takes up the order dated 7/11/2019. My lord has got that order.
Yes.
Now, your lordship kindly sees the substantial question of law that has been framed was whether the learned courts below had misread and misconstrued note number 3 of Exhibit 3, that is Jamabandi, leading to incorrect finding of fact on issue number 5, which has vitiated the judgment and decree impugned herein on ground of perversity. Now, your lordship will kindly take note of the fact that the only issue pertinent in so far as adjudication of the second appeal by virtue of this order is issue number 5. And issue number 5 relates to Jamabandi. Now, one difficulty which I was discussing with my learned friend was the records are here which will have to be appreciated, and the records are in vernacular. If this honorable court is comfortable with the records, then obviously we proceed well. Otherwise, my lord, there has to be a way out for appreciation of that particular piece of evidence. I'm going to completely confine my submission to only issue number 5, and issue number 5 relates to the Jamabandi.
It's okay.
Now, if your lordship permits,
Yes, yes,
we will proceed.
I can understand.
We will proceed. Now, your lordship kindly, my lord, appreciates the factual matrix of the case, which I'll place in nutshell. My lord, two.
Respondents are all represented, all of them.
No, he is appearing.
I'm appearing for the plaintiff.
He is respondent number 1 here, I suppose.
I am the principal respondent here, plaintiff, and others are pro forma respondent. They were basically defendants in the original suit. So their presence otherwise not required because I obtained the decree for recovery of first possession. And that was challenged before the learned trial court, appellate court, that was dismissed. So they are before this novel court. 2 judgments are in my favor. So now this is the third one.
So my basically rivalry is with the plaintiff. So far the other co-defendants are concerned, they have not contested in the suit. They haven't filed their written statement either. Even subsequent in course of time also they were made pro forma. They did not turn up even in this instant proceeding also. As I understand, they have not turned up. So my lord, their presence perhaps won't be required for adjudication of this second appeal in my humble contention.
Why has this been brought up in this haphazard manner without service, complete service of notice?
My lord, as I am given to understand that my learned friend appears for the principal respondent. So the matter was ready for hearing since the records are here. So now this is in the hearing column. And my lord, I also have a stay operating in
Your
upon,
favor.
yes, from this honorable court under Order 41 Rule 5, the petition in the form of IA. In that, there is a stay operating over the execution proceeding.
Joyous Das is the respondent number 1.
And he is the plaintiff in the suit.
You are representing Joyous Das.
Yes, Lord.
And
Others respondents were the defendant in the original suit. The other defendants. He is defendant number 6. Those were
15,
They are the defendants. in
1
the
to
suit.
5.
1 to 5.
They are dependents.
Yes, and they have been
Dependents of?
Defendant in the original suit.
defendants number 1
Original,
to 5.
1 to 5.
And I am the defendant number 6 in the suit.
Hmm.
I am the appellant in the title appeal, and now I am the appellant in the second appeal.
One dependent was struck off, respondent,
Hmm.
deleted, Shabnam Bibi,
Hmm.
because she's married and she stays somewhere else.
Hmm.
They have no interest in the suit.
Exactly, Lordship. They did not prefer any appeal because basically when the suit was decreed and thereafter they did not prefer appeal before the lower appellate court. Now here in this case they have no interest because they are not in possession of the property.
I am the only contesting party right from the beginning. I filed my written statement during the suit stay. I preferred appeal thereafter against the judgment.
Where is the first?
But there was no
appeal at which page?
counterclaim on their part.
Huh?
They did not file any counterclaim with regard to their right.
First appeal at which page?
My lord, first
appeal order?
The first appeal order, your lordship will find starting from page number 51.
No. The first appeal memo.
Appeal memo, your lordship will find
I
is
just
not,
checked the
that
appeal.
is something that has not been annexed.
Okay.
The judgment and decree has been annexed.
Yes, judgment and decree has been annexed in which the grounds of the appeal that has
No,
been
it's okay, we'll get into the LCR.
Yes, that
September.
is there in the LCR, and the grounds have been replicated in the implement judgment and decree of the appeal.
So. Okay. Yes.
Now, in so far my grounds, the relevant ground which has been formulated in the form of substantial question of law in the memo of appeal would be ground number 10, my lord.
Hmm.
I have to confine myself to the substantiation
Okay.
of question
Yes. Only
of
that
law
one.
frame.
Yes.
So ground number 10 would be the relevant ground of appeal during at the first appellate stage, which was in regard to issue number 5. Now, issue number 5 is something, my lord, that has been taken note of by this honorable court while admitting the appeal, and a substantial question of law has been framed in regard to note number 3 of exhibit 3 of the Jamabandi. Now, I have to, my lord, explain the factual matrix, the factual backdrop of this case in nutshell, my lord. What happened? There were two persons, one Ishad Ali and the other Arfan Ali. They were the pattadars of the suit patta number 8. Now, on the death of Ishad Ali, his son inherited the property which was owned by Ishad Ali, and his son also purchased, according to the plaintiff, the entire share of Arfan Ali. So the entire suit patta number 8 was automatically devolved upon the son of Ishad Ali. Now, thereafter, this Watir Ali, who is the son of Ishad Ali, sold his entire share of the land to one Nirendra Kumar Roy, and then subsequently Nirendra Kumar Roy sold his entire share to one Abdul Khalek, and the plaintiff claims to have purchased the suit land from Abdul Khalek. And in that process, the plaintiff is of the contention that this suit patta, the entire land of the suit patta, has been exhausted by way of purchase and subsequent purchase, and eventually the plaintiff being the last purchaser who had purchased and has been in possession, and then he was dispossessed as alleged, as according to him the defendants started construction towards the southern and eastern side of the suit land, and in that way he has been dispossessed. That is the case that has been made out, and the one aspect which he has highlighted over and over again is that the land that has devolved on him by virtue of purchase and subsequent purchase has eventually rendered the entire land in the suit patta exhausted. meaning thereby that the earlier owners, they did not, there remained no sellable right for those patadars over the suit patadar. That was his basic contention. Now, I contested the suit by filing my written statement. And I said that I have purchased my share of land from Arfan Ali, who was one of the two patadars right at the very beginning, as per the plaintiff's own pleading. There were two patadars,
Yes.
Ishad Ali and Arfan Ali. So I say that my vendor was Arfan Ali. And my right, my title and interest as well as possession has accrued from the clear title of Arfan Ali. And their contentions all throughout, the plaintiff's contention all throughout has been that Arfan Ali could not have sold any share of land to me
Because he had no sellable rights.
there was no sellable rights.
Because it was not partitioned.
Yes,
They're
and
brothers.
yes, and Watir Ali, who happens to be the son of one of the two patadars, that is Ishad Ali, had inherited Ishad Ali's property and purchased entire Arfan Ali's property, that is their contention. To that effect, they have exhibited documents, they have produced their registered sale deed. Even I have adduced evidence to the extent of submitting the registered sale deed, by virtue of which I purchased the land sometime in the year 1997 from Arfan Ali.
Entire land.
The suit land that is in question, the claim that I am making,
Okay.
I adduced
Only the
evidence.
suit land.
Now, the thing that boiled down to was the fact that whether Arfan Ali had any sellable right remaining, so as to me being
Yes.
the
Yes.
lawful vendee of
It boils down
Arfan
to
Ali.
that point only.
It
because
only boils down to
only-
that point, which has been taken note of by this honorable court, and substantial question of law has been framed to that effect. Now, my lord, I'll not trouble your lordship with this entire judgment and decree of both the courts. I'll take straight away take your lordship to page number 40, which is a continuation of the judgment and decree of the learned trial court. I'll take your lordship to page number 40.
Of the appeal.
Page number 40 of the second appeal, the memo of appeal of the second appeal.
Yes.
Now, your lordship kindly sees issue number 5. May I read this?
Yes,
issue?
yes.
The defendant number 6, in his written statement, stated that he purchased the land described in the schedule of the written statement, which includes the suit land, from Arfan Ali. Now, the PW1 in his examination in chief, in tune with the plaint, stated that Watir Ali purchased the entire land of Arfan Ali, and after such purchase by Watir Ali, Arfan Ali had no land left in the suit patta and dag, and that there is note regarding that in note number 3 of exhibit 3, and the name of Watir Ali is mutated in place of Arfan Ali in the Jamabandi, that is exhibit 3. Now, perusal of exhibit 3 shows that in note number 3, it is written that Watir Ali, whose name is in serial number 23 of exhibit 3, purchased the land of one Ikramul Qazi, whose serial number is 27 in exhibit 3, while the name of Arfan Ali in serial number 17 is still there in the Jamabandi, and no such note is found to be recorded therein, the Jamabandi, mentioning that Watir Ali's name is mutated in place of Arfan Ali, owing to purchase of entire land of Arfan Ali by Watir Ali, as asserted by the PW1. So the plaintiff's assertion that Arfan Ali had no land left in the suit, dag and patta, and as such, he could not have sold land to defendant number 6, cannot be held to be true. Now, the DW1 in his cross-examination stated that the boundary of the land purchased by him, wide registered sale deed number 740 dated 25/4/1997 is follows, then the description of the boundaries. So here, my lord, in the findings of issue number 5, the learned trial court has in fact negated that assertion of the plaintiff. The assertion of the plaintiff was that the name of Watir Ali has been mutated in place of Arfan Ali, as per note 3. Now, here on perusal of the Jamabandi and the note 3, what was traced out, or what was found was that name of Watir Ali has been mutated in place of one Ikramul Qazi, whereas the name of Arfan Ali still remains at serial number 17 of the Jamabandi, meaning thereby that Arfan Ali's right in the records of right still remained. And if his name in the record of right still remained at that point of time, then obviously he had sellable right, and I am only claiming through him. I am not concerned about the purchase of the land by the plaintiff from Asadul Haq, who had purchased it earlier in point of time from Niranjan Kumar Roy, and who had purchased in turn earlier from from Watir Ali. I am not on those lines. My only contention is that my suit land, in fact,
This
my
matter was
portion.
earlier heard.
My lord,
This
I am
matter
not
was
aware.
earlier heard.
I am not aware, my lord,
Which
because this
portion?
is the first time. Was it earlier heard?
No, no, no. So
There were
first time,
no,
Lordship,
there were markings on the.
the markings probably at the time of admission of the
Okay,
appeal.
okay, yes, yes, correct.
So this is my basic contention. Now here, after recording the factual aspect on appreciation of the record, that is the Jamabandi, the learned trial court eventually decided the issue in the affirmative against the defendants, more particularly defendant number 6. And in the appeal, though we have taken this issue number 5 as one of the grounds, but unfortunately, while adjudicating the issue number 5 de novo, your lordship will find, if I take your lordship to the discussion in regard to issue number 5 by the learned first appellate court, that is the longest discussion. That is in fact a culmination of discussion of two issues, that is issues number 4 and 5 together at page number 58 of my memo of appeal, 5A.
This 58, this is by the civil judge.
This is by the civil judge. This is by the civil judge in the title appeal. Now, your lordship will see it starts from page 58, discussions as regards issue number 4 and 5. And initial discussion is all regarding the other exhibits by which the plaintiff has proved the title of himself as well as his earlier vendors. Now, when the question of Jamabandi that has been discussed is at page 63. In continuation of the discussion of these two issues, your lordship kindly sees at page 63. Paragraph number 24, may I read, my lord?
Yes, yes.
On the contrary, the defendant number 6 based his right over the suit land, claiming to have purchased the same from Arfan Ali, White Exhibit A, registered deed dated 25/4/1997. It has to be said that there was no counterclaim on the part of defendant number 6. The said issue need not be discussed through the learned trial court, though the learned trial court had also delved into the issue of the right title and interest of the defendant over the suit land. DW1 in his evidence also had introduced Exhibit B, which is a rectification deed, but has not clarified as to why the same was introduced, and in fact, the same does not find any mention in his written statement. Again, after comparing the boundaries of the land purchased by the Exhibit A deed with the boundaries of the suit land, it has to be said that they do not match, and it has to be said that it is difficult to presume that the suit land is within the aforesaid purchased land. Further, the existence of land of plaintiff, that is the suit land, is also brought out in Exhibit 8 deed of one Babul Chandra, being deed number 3793, dated 27/2/2002, and the same has also been duly proved by PW6, through the original sale deed. Though the learned trial court has pointed out that Exhibit L shows that Arfan Ali still has sellable interest left in the suit patta, the same has not been proved to be the suit land by the defendant's side. Now, this is the discussion in respect of the Jamabandi. This is the only discussion. The fact that the plaintiff's assertion was held not to be true by the learned trial court, and why it was not held to be true by virtue of the appreciation of note 3 of Exhibit 3, which was exhibited by the plaintiff side. Now, here the discussion is in respect of the same Jamabandi which even we relied upon as Exhibit L. Now, in discussion of that, in discussion of Exhibit L, the discussion and eventually the adjudication by the learned trial court was not appreciated here. And the only thing that has now been taken up by the learned appellate court is the fact that the defendant number 6 has not filed any counterclaim to claim his right from the plaintiff. Now, in my respectful submission, madam, the plaintiff's case of clear right title interest over the entire suit length has to stand on its own feet.
Yes.
Onus will shift only when the plaintiff has discharged his liability in full on the lines of the provisions contained in the Indian Evidence Act erstwhile. Now here, although they have adduced all the evidences so as to prove their title, the derivation of their title, but when it comes to one of the co-pattadars, that is Arfan Ali, their assertion was that Arfan Ali had no sellable right remaining in the suit patta, but from the Jamabandi it transpires otherwise. So the moment that happens, clear title of the plaintiff automatically is
So
clouded.
you are saying that counterclaim is not required to.
It is not required because their case has to stand on their own feet first. Their clear right title interest will have to flow from their pleadings substantiated by evidence. Now, the evidence that they relied upon, it is not that Exhibit L was introduced for the first time during the suit proceeding. It was their evidence. Exhibit 3 was their evidence, and on the basis of their evidence, they pleaded something which is perverse. That aspect was taken note of, and that was in fact recorded correctly by holding that insofar as the note 3 of Jamabandi is concerned, there it does not say like that, that the name of Watir Ali has been replaced or mutated in place of Arfan Ali. His name has been replaced. His name in fact has been introduced or incorporated, replacing the name of one Ikramul Qazi. But so far the name of Arfan Ali is concerned, it still remains at serial number 17, meaning thereby that his name in the record of rights
Yes, I got
is
it.
there. So on the basis of that, we came before this honorable court and the substantial question of law has been framed to that extent. I confine my submission only to that extent, my lord, that in decreeing the suit for right title and interest, first of all, the plaintiff has to prove his clear right title and interest. In my respectful submission, the plaintiff failed to do so. The plaintiff has exhibited various documents, right from his own title deed to the title deeds of his vendors, to the title deeds of his vendors' vendors, right till the top. But one thing that got missed out was one of the co-pattadars who was mentioned by the plaintiff in the plaint being one of the co-pattadars in the suit patta. Now, he remained intact insofar as his rights in the record of rights is concerned. And the assertion of the plaintiff that there was the exhaustion of his entire land, meaning thereby that there is no sellable right of any portion of the land from the suit patta. That aspect got negated on appreciation of the Jamabandi by the learned trial court. Eventually, this aspect was not taken into consideration while deciding issue number 5 as regards right title interest of the plaintiff over the entire suit length.
See, you will have saleable rights when the land is partitioned in your name, then you have saleable rights.
Exactly.
Co-pattada, you won't have saleable rights.
And my lord, that is why there was no claim for partition either. Because the suit was by the plaintiff, it is not my suit.
Yes.
The suit was by the plaintiff. Now, in the suit, there was also no prayer under Order 26, Rule 9 CPC for demarcation, for measurement or demarcation, or for partition. So, in that view of the matter, if my land is intruded in the suit land, there cannot be a decree on the suit land which encroaches or which attracts some portion of my land, because that will be apparently that will be injustice upon me. Now, my lord, I have not filed any counterclaim. That cannot be taken against me to decree the suit of plaintiff whose case has to stand on its own feet. And the documents, the materials which the plaintiff relied upon.
You have purchased the land from Arfan Ali.
Arfan Ali, by registered deed. The registered deed number
And
and
Arfan Ali's name is still in the
Jamabandi.
in the Jamabandi,
In the note
that
three.
note 3.
no, that is my case. That is my case.
Yes, what do you have to say? Anything else?
My lord, I'll, for the
Good
time
time.
being, I'll rest my case
Yes,
like my
yes,
lord.
completely. Yeah, completely, yeah, exhausted, yeah.
I'll thereafter respond to whatever is.
Then again, I will respond. First of all, Lordship, my learned friend has completed his argument by referring to issue number 5 only.
Mm.
Now, before going to issue number 5, there is issue number 4 in the judgment and decree before the learned trial court. Now, issue number 4, with regard to discussion of the right title interest of the plaintiff. Now, the status of the defendant in the original suit was that he filed the written statement only. There was no counterclaim. And now the question of law, basically it's a question of fact. I will rely on a judgment that this sort of question of fact.
No, you cannot.
Yes, Lordship, I am having that judgment. This is a question of fact. This is not a question of law. But this particular question of fact or question of law that has been taken into account is with regard to Jamabandi. Now, Jamabandi is not the substantial proof of evidence with regard to right title interest of a particular person.
Yes.
So long as you have not filed any counterclaim. Because I am relying on certain sale deeds, starting from my vendors, then their vendors, and like that.
No, you don't have to go so far.
No, why I'm saying so, because he has referred to all these things, Lordship. He has referred to all these things. That is why I'm submitting. Because he is saying that I am just relied on the sale deeds only. But with regard to the apportionment of share or the partition and all these things with regard to Watar Ali and the other person, that has not been properly proved by the plaintiff. And now since the plaintiff is to stand on his own foot and that the plaintiff has not done, and subsequently the evidence tilted towards the defendant. It's not like that. Because whatever document I had exhibited, that had proved my right title interest over the suit land. And so long as you are not having any counterclaim and you have not agitated the issue with regard to those sale deeds, challenging those sale deeds, you cannot take a plea that Jamabandi, because of that Jamabandi, the entry there in the Jamabandi, his right remains. Because the Jamabandi is not the substantial proof of right. Because in that particular Jamabandi with regard to a particular patta, whatever land is there, I have sold that particular land by way of a sale deed, the other vendor of the plaintiff. Now, if you had sold the land with regard to that particular land that was there in the patta, then if that particular sale deed has not been put to challenge, then that remains, because the sale deed remains. Now, with regard to that, that is why I am submitting, Lordship, because the Jamabandi is not the substantial proof of title, so long as it has not been correlated by other things. Because I have exhibited all those sale deeds and which were proving the fact that there is a chain of transfer of title, and that is there. So, I am just referring to the issue number 4, which relates with the right title interest of the plaintiff. Now, this issue number 4, Lordship, I'm just referring to issue number 4. The plaintiff claims his right title interest over the suit land on the strength of his purchase of the suit land from Abdul Khalek. The PW1 in his examination in chief supporting the assertion of the plaintiff narrated how the vendor Abdul Khalek got the title over the suit land, which is sold to the plaintiff. PW1 stated that Ishad Ali and Arfan Ali were pattadars in the suit patta number 8, and on death of Ishad Ali, his son Watir Ali inherited the share of his father Ishad Ali, and in support of that has exhibited the Jamabandi of the suit patta of exhibit 3, which goes to show that Watir Ali inherited the land of Ishad Ali. PW1 further stated that Watir Ali sold the suit land measuring 8 katha out of that land owned by him to Nirendra Kumar Roy in the year 1981 by registered sale deed number 5209. And in support has exhibited the certified copy of the said sale deed as exhibit 4, and to prove that has called for the original book volume from the sub-registrar office and examined Uttam Kumar Das, the assistant sub-registrar as PW6, who stated that he brought the book volume number 33 in respect of registered sale deed number 5209, and that copy of the original document has been entered into 2122 book number 1, volume number 33, and that exhibit 4 is the certified copy of the said document number 5209, which is furnished from the said book volume, and that the deed has been executed by Atir Ali in favor of Nirendra Kumar Roy. So the plaintiff has proved the exhibit 4 PW1 then goes to show that Narendra Kumar Roy sold the suit land to Abdul Khalik by registered sale deed number 1230 dated 9/9/1987 and exhibited the certified copy of the said sale deed as exhibit 2. The plaintiff to prove exhibit 2 has called for the original book volume and examined Satyendra Chaudhary, the assistant deputy registrar as PW5, who stated that he is deposing from his book number 1, volume number 37 of the year 1987. And the copy of the said registered deed is entered in page number 3033, and that the deed has been executed by Narendra Kumar Roy in favor of Abdul Khalik Lashkar, and the certified copy of the said deed is furnished from the aforesaid book volume, and exhibit 2 is the certified copy of the said deed. So the plaintiff has proved the exhibit 2 and so has managed to show that the suit land was sold by Nirendra Kumar Roy to Abdul Khalik. Again, PW1 stated that he purchased the suit land from Abdul Khalik on 25/1/1991 by registered sale deed after paying consideration money of rupees 20,000 and has exhibited the original of the said registered sale deed as exhibit 1 and the signatures of the vendor Abdul Khalik as exhibit 11 to 15. Plaintiff examined Abdul Khalik as PW7, who stated that he sold the suit land to plaintiff by exhibit 1 and that exhibit 11 to 15 are his signatures and that he delivered possession of the same to plaintiff. The plaintiff also examined Abdul Latif Lashkar as PW3, who stated in his examination chief that he know both the plaintiff and the defendant side and that Abdul Khalik sold the suit land to plaintiff by exhibit 1 and delivered him possession of the suit land. And while registration of the sale deed, he was the identifier and exhibit 18 is his signature. So the plaintiff has proved the exhibit 1 and the fact that plaintiff has purchased the suit land from Abdul Khalik and got possession over the suit land. Now the PW1 in tune with his claim stated that he was dispossessed from the suit land as the defendant constructed boundary wall in the southern side of the suit land. The PW2 also stated in his evidence in chief that the defendants constructed pakka wall in the southern portion of the suit land and also constructed a temporary shed over the suit land. So PW2 has corroborated the PW1 as regard to fact of dispossession of the plaintiff by the defendants from the suit land. The defendants could not shake the evidence. This is important, Lord. The defendants could not shake the evidence of PW2 in his cross-examination. So it is held that plaintiff was dispossessed by the defendant from his suit land. Now the next portion is the written statement. The defendants in their amended written statement stated that the predecessor interest of plaintiff Watir Ali sold his entire interest over the land possessed by him to defined persons and he had no sellable interest left, so the plaintiff could not have acquired any lawful right, title, interest or possession over any land. Now the defendant has failed to prove their said contention as in the Jamabandi exhibited by them as exhibit L goes to show the name of Watir Ali to be there at serial number 25 and the Jamabandi does not speak anything of Watir Ali selling all his land and losing his sellable interest. The defendant has not proved their said contention that Watir Ali has lost his sellable interest over any land. So the said contention of the defendant cannot be held to be true. So that point was never there, doctor. In the written statement also, what my learned friend is asserting right now, with regard to Atar Ali and the other person, they are having some joint property, there was no apportionment, partition, something like that. This statement was never done in the written statement. It's a new plea they are taking in the second appeal. Whether they can take that plea, they cannot. So that aspect of the matter has been dealt with by the learned trial court while allowing the or decreeing the suit. Is that what they contended? The contention was there that Watir Ali has no sellable right because he had executed the sale deed in favor of the vendor of the plaintiff. So he had no sellable right so far as the sale deed is concerned. But there was no document with regard to that. How you have proved that? Because the name of Watir Ali was very much there in the copy of the Jamabandi. That was the substantial proof of title over the land and that was accordingly sold. The sale deed, registered sale deed was there and that was very much proved by way of calling the volume book. So the chain of transferring the title was very much there and that has been proved. Now the other issue with regard to issue number 5, what my learned friend has said. What that issue? The issue number 5 was with regard to whether the defendant number 6 and his vendors have right title interest over the suit land. That issue cannot be taken into account in absence of any counterclaim. Because in the suit, in the main suit, the prayer was only with regard to declaration of my right title interest. If you don't have any counterclaim, how this issue can be taken into consideration? This cannot be because there was no assertion or there was no prayer on the part of the defendant number 6 claiming his right over the land. So that is the reason why Lordship, the learned lower appellate court took note of that aspect of the matter, the illegality with regard to declaration of the decision with regard to the defendant's right over the 6 rights over the suit land. So that issue was taken into account by the learned trial court. Now how it has been dealt with. The issue number 5.
Yes.
The issue number 5, just now I'm referring to, Lordship. The issue number 5, the defendant number 6 in his written statement stated that the purchase the land described in the schedule of the written statement, which includes the land from the Arfan Ali. Now the PW1 in his examination in chief, in tune with the plain, stated that Watir Ali purchased the entire lane of Arfan Ali. So he had purchased the land of Arfan Ali. And such purchase by Watir Ali, Arfan Ali had no land left in the Sud Patta and Dag. And then there is no note regarding that in the note number 3 of the exhibit 3. And the name of Watir Ali is mutated in place of Arfan Ali in the Jawamandi, that is exhibit 3. Now, perusal of exhibit 3 shows that in note number 3, it is written that Watir Ali, whose name is in serial number 23 of exhibit 3, purchased the land of one Ikramul Kazi, whose serial number 27 in the exhibit number 3, while the name of Arfan Ali is serial number 17 still there. Only the name remains. The name in the Jamamundi copy that remains, but they had not exhibited any document showing that during the relevant period of time, Watir Ali had no saleable right over the suit land. So that aspect of the matters, the part on the part of the plaintiff is over, because the plaintiff's role is limited to the extent of proving his right interest over the suit land. That was very much established by way of exhibiting all the relevant sale deeds, and those sale deeds were duly proved by the calling the Folion book. So the learned trial court came to a finding that the plaintiff had duly proved his right over the suit land. Now, when the appeal was preferred before the lower appellate court, Lordship, that aspect of the matter was taken into account by the lower appellate court. The issue number 5 and 6, 3 and 5 and 4 and 5 was clubbed together, and accordingly it was taken into account. Now, the relevant portion, the finding, I'm just referring to the finding, Lordship. This is a page number, paragraph number 20. Paragraph number 20, Lordship. The learned advocate for the appellant in appeal memo as well as in his argument has submitted that the plaintiff has failed to prove his title and the challan chain leading to the title of his vendor, though he has not elaborated or cited any case laws to substantiate his argument. On the other hand, the respondent plaintiff side has argued that the purchase deed of the plaintiff has been duly proved by not only examining the plaintiff but also the vendor and one of the witnesses who identified the vendor. Further, it is also argued that the exhibit 2 and exhibit 4 sale deeds, which are certified copies of registered documents, have also been duly proved by examining the relevant book volume in which the entries had been made before the authorities. Now, Section 61 of the Indian Evidence Act provides that the contents of a document may be proved either by the primary or by secondary evidence. Primary evidence under Section 62 means the document itself produced for the inspection of the court. Secondary evidence under Section 63 means and includes certified copies given under subsequent provision, copies made from the original by mechanical process, which is themselves ensure the accuracy of the copy, and copies compared with such copies, copies made from and compared with the original, counterparts of documents, oral accounts of the contents of a document given by some person who has called seen it. Section 79 of the Evidence Act also mandates that court shall presume to be genuine every document purporting to be a certificate, certified copy, and other document which is by law declared to be admissible of any particular fact, and which purpose to be duly certified by any officer duly authorized either by the central or by the state government, provided that such document is substantially in the form and purpose to be executed in the manner directed by law in that behalf. An objection in relation to admissibility of a document should be raised before any endorsement has made by the court. So objection was not there. When those documents were exhibited during the relevant period of time, those documents were not under objection. And the court is required to form its opinion on the question of admissibility and express the same, on which opinion it will depend as to whether the document being endorsed is admitted or not admitted into evidence. In such and such 2003 ATSCC, the Honorable Supreme Court has held that the learned counsel for the defendant respondent has relied on the Roman Catholic mission such and such support. This is with regard to the admissibility of a particular document. Now, Lordship, this the next page, Lordship. In the latter case, the object should be taken before the evidence is tendered. So what I'm submitting, Lordship, the objection with regard to sale deed was not there during the relevant period of time. In the latter case, the objection should be taken before the evidence is tendered, and once the document has been admitted in evidence and marked as an exhibit, the objection that it should not have been admitted in evidence, or that the mode adopted by proving the document is irregular, cannot be allowed to be raised at any stage subsequent to the marking of the document as an exhibit. The latter proposition is a rule of fair play. The crucial test is whether an objection, if taken at the appropriate part of time, would have enabled the party tendered the evidence to cure the defect and resort to such mode of proof as would be regular. So this is with regard to that particular judgment which has been referred before the lower appellate court. Now, Lordship, paragraph 21, with regard to finding of the lower appellate court. Because there was some objection with regard to the admissibility at the appellate stage, Lordship. Now, paragraph 21. Therefore, it has to be said that the objection as to admissibility of documents into evidence are of two categories. One being an objection that the document which is sought to be proved is itself inadmissible in evidence, and the other being when the objection is not with regard to admissibility of the document, but is directed against the mode of proving it, alleging the same to be irregular or insufficient. Here in the instance 2, the defendant side never raised any objection in respect of any of the Exhibit 2 or Exhibit 4 document, and no objection was raised as regard the manner of their proof. Hence, once the documents have been marked as an exhibit, it is impermissible to allow the defendant appellant side to take a plea that the mode adopted for proving the document is irregular, as failure to raise a prompt and timely objection amounts to waiver of the necessity for formal proof of document. So that objection that was subsequently raised at the appellate stage with regard to the admissibility and all these things, that has been set aside by the learned lower appellate court. This cannot be taken at the belated stage. Now the paragraph number 22, Lordship. Now section 54 of the Transfer of Property Act defines sale as a transfer of ownership in exchange for a price paid or promised or part paid and part promised. Such transfer in the case of tangible immovable property of the value of 100 rupees and upwards, or in the case of reversion or other intangible thing, one can be made only by registered instrument. In the case of tangible immovable property of a value less than 100 rupees, such transfer may be made either by the registered instrument or by delivery of the property. Therefore, to be a valid sale under the law, it is not required to execute in presence of attesting witness, and if that's so, it will not be impermissible to examine the attesting witness even if there are some attesting witness in the sale deed. Therefore, section 68 of the Evidence Act would not be attracted in the case of a registered sale deed. In order to prove a sale deed, it is also not necessary in all circumstances to examine the vendor or the attesting witness or even the scribe. Section 51. So all these things, this particular paragraph relates to the Transfer of Property Act and the relevant section with regard to sale deed. During the appellate stage, Lordship, lower appellate court, there is the objection only with regard to the mode by which those documents were exhibited, the sale deeds. Here in this, before this honorable court, they are raising the plea with regard to the Jamabandi and the name that was there in the Jamabandi copy. That point was never raised before the lower appellate court. That point was never raised before the initial stage of the while filing the written statement, Lordship. New point that has been raised before this second appellate stage, Lordship. Now, paragraph number 23, Lordship. Paragraph number 23. Herein, the plaintiff side not only proved exhibit 1 by adducing the evidence of the executants and one witness, they proved the exhibit 2 and exhibit 4 by summoning the witnesses from the office of the sub-registrar along with the records to prove the contents of the sale deeds contained in the original volume register of the sub-registrar office. The defendant had taken the plea as DW1. The predecessor interest of the plaintiff, Watir Ali, had sold his entire interest over the lands possessed by him to defined person. That plea was taken. The plea was taken that Watir Ali, before selling out his share of land to the vendor of the plaintiff, had sold the land to some other persons. So at the point of time when he sold the land to the vendor of the plaintiff, he was not sellable right about the land. Now the different plea has been taken now that during the relevant period of time, the other person's name was there. So since his name was there, the unpartitioned property, it cannot be sold out. So that plea was never raised at the relevant point of time, at the time of submitting the written statement. So that aspect of the matter has taken into account by the lower appellate court. The defendant had taken the plea as DW1, the predecessor interest of the plaintiff. Watir Ali had sold his entire interest over the land possessed by him to defined persons, and he had no sellable interest left. And so the plaintiff could not have acquired any lawful right at interest or possession over any land. However, he has not denied that Watir Ali had sold 8 kathas of land to Nirendra Roy, and in fact has admitted to the said fact. So he had admitted that aspect of the matter in the cross. The defendant had tried to prove his contention through Exhibit 1, Exhibit L, the Jamabandi of the suit patta, but a careful perusal of the same as reflected by the learned trial court in his judgment. The name of Watir Ali is seen to be there at serial number 25, and the Jamabandi does not speak anything of Watir Ali selling all his land and losing his sellable interest. No evidence has been laid by the defendant's side to prove that the said Exhibit 2 and Exhibit 4 sale deeds had not been executed. In fact, from the evidence of DW1 as stated in para 8, it is seen that he had admitted to the fact that Haji Watir Ali had sold 8 kathas of land to one Nirendra Kumar Roy by registered sale deed number such and such. Further, the evidence of PW4, Harun Mia, who happens to be the son of late Watir Ali, also corroborates to the execution of the Exhibit 4 deed, and he also corroborates the title of Watir Ali over the land in the suit patta. On the contrary, the defendant number 6 based his right over the suit land, claiming to have purchased the same from Arfan Ali by Exhibit A registered deed dated such and such. It has to be said that as there was no counterclaim on part of the defendant number 6, the said issue need not be discussed. So I made a mention with regard to that, Lordship. There is no counterclaim asserting his right over the land. Was no counterclaim on the part of the defendant number 6, the said issue did not be discussed, though the learned trial court has also delved into the issue of the right title interest of the defendant over the suit land. DW1 in his evidence also introduced Exhibit 8, which is a rectification deed, but has not clarified as to why the same was introduced, and in fact, the same does not find any mention in his written statement. Again, after comparing the boundaries of the land purchased by the Exhibit A deed with the boundary of the suit land, it has to be said that they do not match. So the only document that the defendant number 6 was relying was a sale deed. Now, if the particular sale deed, which I am relying, because this is their document, Lordship, that the boundary is not matching with the boundary of the suit land. So admittedly, you are saying that I'm in possession of a defined land. So if you are possessing on a defined land, in absence of any counterclaim, whether you can say that the plaintiff has not proved his right title interest. I have duly proved my right title interest. And this is my submission, Lordship. There is nothing in the second appeal. It has been filed just to delay the execution
Any
of the.
written argument or objection or anything?
And with regard to one aspect of the matter, Lordship, I'm just referring to one judgment. I'm just referring to one judgment of the Honorable Apex Court, Lordship. Principle, I'm just substantial question of law and question of fact, distinction. So the distinction is there. Which one goes to show the question of law and which is called.
What is name?
This is 2020-19 SCC. I'm just giving that judgment, Lordship, page number 57.
Right.
2020-19 SCC, page number 57. This will clarify the entire aspect of the matter.
All right.
I started with my argument that this is not a question of law, this is a question of fact. Obliged, Lordship.
You want to reply?
Yes, sir. Now, my learned friend has come hard on the aspect that insofar as the issue
Yes.
number 5
Oh,
is concerned,
Issue number 5.
now that could not have been framed because there was no counterclaim. And the issue number 5 was actually dealt with by the learned trial court beyond jurisdiction, something that has been taken note of by the learned appellate court. But my respectful submission on this
That you have
aspect,
replied, no?
on this aspect
already.
is there, so far this dealing with issue number 5, if it was erroneous, even in that case, coming under order 41 rule 1 section 96 CPC, I have preferred appeal against the entire judgment and decree. But so far the plaintiff is concerned, that aspect has not been brought by way of a cross examination, by way of a cross objection, the provision of which is in order 41 itself. Your Lordship will appreciate insofar as
Order 41?
I'm my lord citing the exact provision.
So I do very CPC to diason. I do check over. So good. Yeah, thank you.
Your Lordship will kindly take up order 41 rule 22.
Yes.
Upon hearing, respondent may object to decree as if he had preferred a separate appeal. Any respondent, though he may not have appealed from any part of the decree, may not only support the decree, but may also state that the finding against him in the court below in respect of any issue ought to have been in his favor, and may also take any cross-examination, cross-objection to the decree which he could have taken by way of appeal, provided he has filed such objection in the appellate court within 1 month from the date of service on him or his pleader of notice of the day fixed for hearing of the appeal, or within such further time as the appellate court may see fit it to allow. Now, my learned friend has come up hard upon issue number 5. Where was his cross-examination? Where was his cross-objection? In the first appellate, as per first appellate court, as per the provisions of order 41 rule 22,
Yes,
at the first place.
Right.
And my lord, another aspect of the matter is Now, while the first appellate court delved into this issue in holding that I did not file my counterclaim, but the fact remains that the issue that was adjudicated by the learned trial court, that has not been re-adjudicated by the learned first appellate court as it is. When it comes to re-adjudication or re-appreciation of the issue,
You counterclaim, you'll file it in the beginning.
that is
Not
in the
now.
beginning at the time of filing of the written statement. Now, the finding of the first appellate court in regard to issue number 5 is not touching upon the note 3 of Jamabandi. And my lord, one aspect that that my learned friend has highlighted is that in my written statement, my pleaded case was something different. What I had stated in the written statement was that Watir Ali does not have sellable rights. My lord, that is another aspect. Now, I am not going into that aspect at this stage of the litigation, the third round of the litigation. That is one aspect that I am not even going into. I cannot, because
Not
the
possible, yes.
substantial question of law that has been framed is on a different footing. Now, on that aspect, your lordship kindly takes up page number 18, paragraph number 7 of my memo of appeal. Their assertion is something that I have denied. It is their assertion that Arfan Ali does not have any sellable right remaining. My vendor, Arfan Ali, does not have any sellable right remaining with us. I have denied categorically this contention raised by the plaintiff. That is the issue that was framed, and that is the issue on which the adjudication has been made. Paragraph 7 of my written statement at page 18, that itself is good enough for me to bring on that aspect of the matter, that
Paragraph 7 of your written
paragraph
statement.
7 of my written statement at page 18.
Only denial, lordship.
Yes, that is sufficient, my lord,
There is not
because
that.
they have to stand upon their own case. They have to stand on their own feet in regard to establishing their case. My role is denial only to the extent of their discharging of liability of onus of proof. My role is only of denial. It is they who have filed the suit, not me.
Okay.
So my case is limited to that extent, my lord, and my humble
Written
prayer.
argument is required, lordship.
Hmm?
Written argument is
Not
required,
required.
not required.
It's okay.
And order 41 rule 22 has no role to play here, lordship, because the substantial question of law has been already been formulated. So the court is to confine with read that regard.
Yes, my lord, that also another aspect. I'm thankful to my learned friend. Substantial question of law in regard to issue number 5, which he is now trying to assail.
Yes, yes.
He did not assail it in the first appellate stage. Here also he cannot take a stand on that. Deeply obliged, lord. My lord, reserved for judgment.
Yes, yes.
Deeply obliged.
I cannot. I have not judged this.
Understand. Lord.
Already, I think I have 17 or 19.
Another matter is there,
pending.
lordship.
I think 2 more matters are
And
there.
one more matter is there, and I have 17 or 19 judgments pending.
My lord, my lord,
I'll have to finish those first.
my lord. Deeply obliged.
Lordship, kindly go through that particular judgment.
Yes, I'll have to go through it.
Yes. Always.
Because I'll have to read the entire judgment.
Exactly, lordship.
Yes.
Deeply obliged.
You will conclude in 1 hour? Will you be able to conclude in 1 hour? Or should we
May not
defer
be
it?
possible, my lord.
Huh?
May not be possible.
Then should we defer it for,
Hello.
I'm so sorry. You were the first ones to come, but I had to check everything.
Yes, yes.
Because their case also I started checking, because
Right.
I cannot take up the hearing without checking.
Yes, yes.
So I'll take up, so I'll just write, pass one order that all the notices have been served.
Yes.
Huh?
Well, yes.
সব সলভ হয়েছে না লার্নার কাউন্সিল মিস একটু আগরটু লিখে দিয়ে So I'll just pass this order and then we will positively hear according to your schedule. Tell me when you are, when you'll be able to.
My lord, I have some difficulty in the first week of September.
First week, it won't be possible.
My
Second,
lord, second week, my lord.
Yes.
Second, any day of the
second week, fine, no?
Second week.
18.
September. My lord, he proposes for 18th of September.
18th of September, yes. Only the last week of September will be a motion week.
Motion, yes.
18. 18 no,
And even if this week is declared as a motion week, we'll take up your hearing.
my lord.
118, 118, 118 well.
এইটো আগতে লিখি লওঁ তাৰপিছত পাছৰটো লিখিম।
Item number 10.
10. Learned Counsel, Mr. M.J. Kadri is present for the appellant and Learned Counsel, Mr. A.R. Sigdar
For respondent number 7.
is present for respondent number 7. First of notice, the office notes and earlier orders. No, the office notes and the record reveals that notices on the other respondents have already been served, but the respondents are not represented. This matter positively for hearing on 18th September, positively for hearing without fail on 18th September.
Well,
Item 15 to litigation, third Learned Counsel Mr. D.C. Chakraborty for the petitioner. Moi SP P.K. Chaudhary will live argument to pin my person and Learned Counsel Mr. SP Chaudhary for the respondent number 1. Reserve for judgment and order.